vindictive. It intended to lower his standing in our community and within the legal profession. It was unwarranted. I have had occasion again to defend Mr. Chebukati, although he was not my client. I was in a different office. But I recall mentioning in 2017, before your lordships, that this gentleman was being vilified for doing exactly what the minor Kiai court told him to do. It told him, don't touch the results coming out of the polling station. That is the final result. We then came here to this court, and he was called all manner of names at that time. This has not stopped. What should we learn from this? We should learn one thing, and it is a very unhappy lesson. The attack on the chairpersons of the commission has a long history. There was Justice Zacchaeus Chesoni, there was Samuel Kivuitu, there was Isaac Hassan, and now there is Chebukati. The pattern is the same. The pattern is the same. None of them has been allowed to leave office without vilification and a vindictive process being engineered against them. I don't want to go to the details because we all know the details. We remember the details. So what is wrong? There is nothing wrong with IEBC. There is nothing wrong with Wafula Chebukati. There is something very wrong. There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem. At an appropriate time, when all this is over, I entertain no doubt that an independent group of people looking at the work that Mr. Wafula Chebukati has done for our nation will recognize him as one of our outstanding heroes in the history of our nation. Thirdly, I want to say that the evidentiary material, which will be addressed by my colleagues, is of such a character that it falls way below the standard you set in petition number 1 of 2017. And since I don't want to take too much time, I'll leave that for that purpose. To return to this issue, that this court, in our very humble view, needs, and I'm very sure from the questions the court has asked so far, that the court appreciates very deeply, and that any order has consequences, and those consequences must be consequences that can be contained in our democratic and constitutional process. The Supreme Court cannot act in vain. It cannot act so as that the judgment should read like a learned legal article. The Supreme Court always acts so that it can defend democracy and the rule of law and constitutionalism in a practical and enforceable way. So if this election is so badly flawed as you are invited to find, then this court would have to find that every MCA, every MP, and every senator and every governor was not properly elected, and the whole of the government of the Republic of Kenya should be reconstituted afresh. I don't know whether my learned colleagues have contemplated the consequence of what they have requested. My client, Mr. Wafula Chebukati, is a man who enjoys constitutional protection of his tenure.